Type of 58. And possibly more than 8 years out of 10 years.
We'll proceed. I'll take it up. Monday weekly. So it can be taken up tomorrow only. Tomorrow only. Because today is dedicated bench.
May I have
Pardon
leave to
to
make?
mention, my lord, this is a criminal revision of the year 2025, and here 2 PML proceeding has been initiated against the petitioner from the same cause. Almost.
Yes. Yes.
Any mention?
Item number 15, my lord, Mr. Das, learned senior advocate, was mentioning that he reached at 3 o'clock in the night. He told me over host that my learned senior brother is there.
No, my lord, I requested him to find out if he has some difficulty, my lord. My lord, I really miscalculated my return time, my lord. So I came back last night at 3 by the time I was home at 3.
Okay, then I'll take it up on Thursday. No problem.
Next Tuesday.
Next Tuesday, okay? No. But next
18th.
next Tuesday he may not be here.
Pardon to mention.
Yeah, you are not participating. You are not participating in the election, it seems.
I have to go, my lord. And Justice Karan
Then why next Tuesday? So next Thursday.
All right.
Next Thursday. Okay. And Supreme Court election is there, he will go, I know. So therefore I am saying. Next Thursday.
So only half an hour, 1 hour.
Okay, next Thursday.
20th.
Yes.
Yes.
Pardon to mention, my lord, this is a joint criminal appeal, and I'm in custody.
Other number item.
I'm in custody since 6 years.
Out of?
Out of 20 years. Yes. Pardon to mention, my lord. CRA number 1401 of 2023. This was before your lordship on 29/7. We have filed an application for extension of interim bail, but in the meantime, petitioner was surrendered. Has surrendered in the court, and your lordship was pleased to direct us to file a fresh application for interim bail. It was pleased to pass pleased to keep it on 7th of August, but in the order it has been inadvertently mentioned as 7th of September.
You move the application and take it up. Don't worry. Yes. Yes. Any mentioning? No.
Supplementary list. Item 1.
This is supplementary.
Here, my lord, on that day, my lord.
Session 9.
Yes, my lord. Session 9. On that day, I have also argued, and lordship also convinced about.
What you have forgotten?
My lord, the 42, my lord. 42 not complete, my lord. On that day, the exhibits are not with me, because that is a prisoner petition and paper book supplied to me. So there is exhibit, absence of exhibit, I can't.
You have given a written note also.
Where the 42 is not complete, Lord. Lord, I am
Have you given to them? Have you given?
Yes, sir.
Yes.
I am relying lordship's judgment in.
First, show me the evidence. Then
My lord.
come to this.
So far evidence is concerned, my lord.
This judgment is Santosh Singh.
Again.
Santosh Singh.
In Santosh Singh, page 12, my lord.
Santosh Singh I have. These two judgments, Santosh Singh I have.
Again.
The copy. And this is another judgment.
Set CRLA 575, my lord.
Okay.
Here, my lord, the operating vehicle is a Innova car, my lord. As lordship observed in Santosh Singh, the car is not a public place. And that is Bhutta Singh and Jagraj Hans, all things described in lordship's judgment, my lord. Here in this case also same, my lord. Here, my lord, while the informant is in police station, he has received, in one part, received the information. So for 42 is concerned, my lord, he has to send the external.
There in Santosh Singh, I said that if it is in the public road,
My lord.
if a car is flying from
Lord.
there, if you recover,
My lord.
then it would be treated as a private place. So therefore, 43 doesn't apply, 42 applies.
Yes, my lord. In this case also, the offending vehicle is a car, my lord, Innova car. And the owner of the vehicle is already ascertained and he has ascertained as a charge-sheeted witness and he has deposed, my lord. The prosecution has not shown anything that the vehicle is public vehicle, my lord. That's why 42 is necessary, my lord.
Yes, 42 is necessary.
Yes, my lord. So for 42 is concerned, my lord, for lordship's convenience, एटा से जो paper book माने all thing to paper book से खाली एटा दवा पे बोल कोचे what they have exhibit, my lord. एटा खुल दे मार दे पड़े ऐसे होते हैं. Only stationary entry. Only stationary entry that is in I have folded, my lord.
Yes, what is this?
Page number 110, my lord. My page number सेटा मु डाउनलोड करके नेला पर मु गोटे पेज मार्क दे देछि.
This is 110, huh?
Yes.
110, yes.
In 110, my lord. Fatehgarh PS SDE number 584 of 3512, my lord. Only the
Where is it?
first, my lord. एकटा जोटा माने सीजर लिस्ट रो तळे जोटा अछि. पेज नंबर 110
Top line.
टॉप रे फर्स्ट रे.
Top, right?
Again. Fatehgarh police PS.
From the place of seizure.
Yes, my lord.
From Fatehgarh.
Fatehgarh station diary entry 584 dated 35/12, my lord.
Yes.
Page 110.
Yes, 35 bar. Yes.
Only the station diary number has been seized, my lord. The extract copy of the station diary not proved before the honorable court, and the station diary, extract copy of this station diary that must be sent to the immediate officer superior. From the officer superior, there is no evidence collected to corroborate the section 42, my lord. जदि से extract copy टा से मैंने देई थांते सेठी की और सेठी जदि inquiry officer जदि seize करिके आणता, that is treated as section compliance section 42, my lord. Here, my lord, nothing has been, only mentioned that station diary entry. In deposition also he has stated that no station diary entry ta seize karichi. No station diary entry has been proved, my lord. And extract copy of the
What is entered in the station diary?
खाली से कहउचंदे जे मो स्टेशन डायरी एंट्री रे करूची बोली. This is the only version. PW7, my lord.
Do you have that entry?
Yes, my lord.
584. Show me 584 entry.
584 तो खाली से सेतिके दउचंदे आ किछ कॉपी नाही. No station diary entry has been proved, my lord. से जो station diary entry रो पेपर टा that has been not proved, my lord. But they mentioned that in Fatehgarh PS I have written reduced interest station diary entry.
Yes.
That's why the 42 is not
But in
non-compliant.
the statement he says that I have sent it. I have sent it.
ହଉଛି ମୁଁ ଦେଇଛି ଆଉ ଏଇଠି ମଧ୍ୟ କହୁଛି ଷ୍ଟେସନ ଡାଏରୀ ଏଣ୍ଟ୍ରିରେ ମଧ୍ୟ ଏତିକିରେ ମୁଁ ଲେଖିଛି ବଟ୍ ଦ୍ୟାଟ୍ ଷ୍ଟେସନ ଡାଏରୀ ଏଣ୍ଟ୍ରି particular station diary entry has not been proved, my lord. And the extant copy of the station diary entry also not seized from the official superior, my lord.
Okay. Then what you are trying to say is neither what you are trying to say is neither the extract of the entry nor the entry portion of the station diary was produced.
That is
So
necessary for to compliance of
therefore 42 is not compliant.
Yes.
That's what you.
Then, my lord, the judgment, my lord. That is my page number 154, my lord. What they have seized.
Then you show me the evidence where the
Yes, my lord.
iOS
That is PW7
in page
page, my lord.
in your page.
My page. My page is
This is there the evidence is there
Conscious.
in this is in this compilation?
Yes, yes, yes. Those. That. Hold করতে সেট তারপর দিয়ে দেন।
Is there? Yes. PW?
PW7.
PW7.
Say Asgar Ali.
Yes. Where does he say that
वो फाइल yes Milord. PW7 Milord.
which paragraph?
Milord. In chief Milord,
Para?
Milord, the second portion Milord. ମୁଁ ପୁରା chief ଟା ପଢ ଦଉଛି Milord.
No, I have read it. Tell me the relevant part.
The relevant part where in the night, page 86.
Where has he said that I have sent the station diary?
No, Milord, where it is not stated the station diary book.
No, it is stated somewhere. I think.
Nothing. See, खाली ଗୋଟେ suggestion ମଗା ହେଇଥିଲା ସେଠି ଖାଲି ସେ କହୁଛି
Where have
ଯେ that suggestion Milord,
record the ganja project?
paragraph 7 Milord.
No. First para 1, he says that
Milord.
then I enter the fact in the station diary.
And then
Then
along with
I,
the
along with the other police staff, namely so and so, police rather left
Milord.
to detect the nuance. Entry is there. Okay? And where does he say that it was sent to the senior officer?
Milord. Senior officer SP has not has a charge sheeted witness, Milord, and nothing has been seized from the senior officer superior office of the senior officer. ସେଠୁ ବି extract copy ର କିଛି ସିଜ୍ ହେଇନି। PW13 is the first IO.
Para 7. Just see. It is not a fact
Milord, only that is
that
the
I get information from the transportation ganja from the sources. I have not made any stationary entry.
Milord.
It is not a fact that I have not informed to the SP over phone. This is over phone.
Milord. That can say coach, but no paper has been produced before the honorable court for proof. And the phone number is also not mentioned, Milord, of the officer superior.
Yes. 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 What do you say?
So for the
seizure only says that the extract, but the extract is not exhibited, not proved, and he says that I have intimated over phone. The phone number is also not there. That is why he says 42 is not compliant.
the 42 in compliance that the vehicle was
Let's see
interested.
42.
Yes.
Milord, I agree.
Report.
So for 42 it
Any
also,
case.
Milord. May I read it?
You have the copy?
Hmm.
Extra copy. What's he? Extra copy?
से जो लॉर्डशिप का कोटेशन टर अछि एटा संतोष सिंह जजमेंट रे 42 टा दे अछि
हाँ, पढ़ो 42.
आई मिलड power of entry, search, seizure, and arrest without warrant or authorization. Any such officer, being an officer superior in rank to a peon, sipai, or constable of the Department of Central Excise, Narcotic Customs, Revenue Intelligence, or any other department of the central government, including paramilitary forces or armed forces, age is empowered in this behalf by general or special order or by central government or any officer, being an officer superior rank to a peon, sipai, or constable of the Revenue Drugs Control Excise, police, or any other department, state government, as is empowered in this behalf by general or special order, the state government, if he reason to believe from personal knowledge or information given by any person and taken down in writing that any narcotic drug or psychotropic substance or controlled substance in respect of which an offense punishable under this act has been committed, or any document or other article which may furnish evidence of the commission of such offense, or any illegally acquired property, or any document or other article which may furnish evidence of holding any illegality acquired property which is liable for seizure or freezing or forfeiture under Chapter 5A of this Act is kept or concealed in any building, conveyance, or enclosed
You are coming under the conveyance. Huh?
conveyance. সেটা conveyance টা भी পরে আসছে না।
Enclosed space.
Yes, Lord. A. Enter into such building, conveyance, or place. B. In case of resistance, break open any door and remove any obstacle such entry. Seize such drug or substance and all materials used in the manufacture thereof, any other article, and any animal or conveyance which he has reason to believe to liable to confiscation under this act, and any document or other article which he has reason to believe may furnish evidence of the commission of any offense punishable under this act, or furnish evidence holding an illegally acquired property which is liable for seizure or freezing or forfeiture under the Chapter 5A of this Act, detain and search, and if he thinks proper, arrest any person whom has reason to believe to committed any offense punishable under this Act, provided that, Lord, in respect of a holder of license of manufacturer or manufacturer drugs, psychotropic substance, or controlled substance, granted under this Act, or any rule or under such power shall be exercised by an officer not below the rank of sub-inspector, provided that
Subsection 2. You read
yes,
subsection
Lord.
2.
Where an officer takes down any information,
This is his bylaw.
yes, Lord.
Where is an officer?
Where an
takes out
officer takes down
the
any
information
information in writing
under
under subsection 1 or records grounds of his belief under the proviso there to be within 72 hours, send a copy thereof his immediate official superior.
This part is not
Yes,
applied
Lord.
according to you.
The 42 is not complied here, Lord.
Yes, what do you say?
That evidence.
And it was recovered from the vehicle.
Vehicle.
It's a private place. 42 is to be required to be complied. 42(2) has not been complied according to him.
But is not invariably required the original is to be produced during trial, because it is immediate over telephone it has intimated.
No, original, duplicate, nothing is produced in this case. Where the IO says,
Only they are not disproved that stationary whatever entry is there in the seizure, that it is not stationary entry in relation to this case. Because it is not brought. This stationary entry 5243.
but only it says stationary
Yes.
entry, but
the
that entry is not there on record, entire record. Station diary is not, number is not important. The entry or extract is important. Where is that entry? What was entered? What was written there? Where is that? What was the information? He says that I have telephonically intimated, but the telephone number is not there. The SP is not examined. So what was the content in that extract? Show me in the record where that extract or station diary entry is placed. Unless that entry is placed on record, just see in the record if you have, you can find that.
Very kind.
That entry is not there. You can see the entire, record to find out. Entry number was, request to, what was the entry number?
Lordship may judgment page 19 making class. The trial court dealt with this issue.
Yes.
Page 19, internal page 6.
Para?
Para 7,
Okay.
the last work,
Yes.
besides this,
Yes.
PW7 took charge of
Besides this, PW7 produced the seizure please.
safe custody.
Seize
Besides
articles
this,
to immediate
on the
effect.
same day, the seized ganja along with samples had been produced for the SDGM Nayagada who forwarded a sample to ganja. The mall items has been kept in the district court Malkan. As such, it is concluded that provision 55 independence has been completed. PW7 produced the seizure list and seized article to his immediate official superior, who was the police IO PW30.
That is what he says. Where is that? His finding is wrong.
It is further.
He says that it is further appears from the evidence of PW7 that before proceeding to the spot, he made the station diary entry and informed the same to the police superintendent of police over phone. Where is that entry? Where is that station diary entry? He says that yes, I have entered it, but is it not necessary to place it on record? And he says that I informed to the superintendent of police. Phone number also he doesn't disclose. Which phone number? Nothing. So this portion he is creating doubt.
The seizure is not in doubt.
Seizure is not doubt. He says that it was
for the
those part he is not questioning.
No, no.
What he is questioning is once the information is received by the IIC, he made an entry in the station diary and telephonically he informed the superintendent of police. Then he proceed to the spot. That part of the evidence that the station diary entry and the telephone in communication has not been proved on record. So therefore 42(2) is not complied.
Then if the seizure is not in doubt and seizure is produced before the learned SDGM in time, so the questioning that a station diary is not produced cannot be fatal to the prosecution case. In between, suppose station diary entry made, seizure has been made. As per the instruction, inquiry has been investigated, IO has proceeded, and all those things has happened.
You then you show me some judgment where it says that once the seizure once the station diary entry is made, it is sufficient compliance. It need not be produced in the court. Whether it is sufficient compliance, because PW7 says that I have made an entry.
Right.
I informed to the police officer. Whether is it sufficient or all these things has to be proved on record by bringing that station diary in record as well as
I will examine the Colonel Singh judgment. That's what I recollect. That Colonel Singh
Colonel Singh judgment is very clear about
whatever this is what you have pointed out.
Yes, sir.
Let him show me this if it is necessary.
And seizure is also in doubt, ma'am. Here below 2 times sample has been taken below. One before the executive magistrate, another before the SDGM.
That you have already argued.
Argued de seta be कहउछ आ गोटे जजमेंट मध्ये गोटे सोनिया पंडा बोली गोटे जजमेंट अछि तो what is the first sample they have taken? There is also necessary the first sample to in the malkhana register. That has been not entered. प्रथम रे जो sample टा बाहर करले सेटा को देलेनी कोर्ट रे.
Okay, you prepare a
Yes,
written note of submission, detailed written note of
Yes, sir.
submission, and give it to him, and he will answer.
Okay.
And what my senior has contended, the no such judgment. If seizure is in a
And I said I will
complaint, then
examine the
section
court and see.
42 is
No such judgment is there.
What is the scope of 42.2?
Milord.
Whether it is mere entry said by deposed by the IO is enough,
Milord.
or he has to produce it.
Milord.
Is it necessary?
ମୁଁ ଦେଇଛି ସେଟା।
Because here one step is ahead, then he is in the seizure list it is there.
Milord. ନାଇଁ CRLS 575 of 2014 Milord I have supplied Milord. ସେଇଟାରେ ସବୁ କିଛି ଅଛି। ଆଉ ଲର୍ଡସିପ ମଧ୍ୟ ସେ ସନ୍ତୋଷ ସିଂ ଜଜମେଣ୍ଟ ର ଏଇ କଥା ହିଁ ଲେଖିଛନ୍ତି ଯେ ନା ନାଇଁ 42 if not 42 is not compliant then entire seizure.
No, in that case, what had happened is the police said that 42 is not required because
No,
it is in
what
public
lordship-
place.
what
So
lordship-
43 applies.
What lordship
I said, since he has not attempted to comply 42, saying that no, 43 applies. I say that no, 43 is not applying, 42 applies. Since you have admitted that you have not complied the 42,
Milord,
therefore,
seizure is if 42(2) is not compliant Milord, then seizure is vitiate Milord. ସେଇଟା ବି ପ୍ରତିଟା ଜଜମେଣ୍ଟ ରେ ଅଛି। Seizure is vitiate.
let us see what he says. Shall I put it Tuesday or
Next week.
Thursday?
Yeah, Tuesday.
Tuesday. For
Problem.
the judgment Tuesday sila for the yes. Yes.
Problem.
Item 2. Huh? Status report. Status report. You got any status reports? There was a direction last time. In 96, you were 65. In the year 96, he was 65.
65.
Appellant.
100. Yes, I attempt to
2.
2. May I say that?
Ooh, exactly.
She is 65 months, some be sure, sir. 96, 30 sure, 95.
96, he was 65.
Nothing. Nothing.
That is the reason I said get the report you have not got. Which police station is she? See the police station.
Yeah, right level.
The home police station. I think you don't see the proceedings.
Like hanging is
Police station. Athoda. This is from Athoda. Get it day after tomorrow. Next. Day after tomorrow, huh? It will be day after tomorrow. Get it. He might have died by now. Yes. 2 and 3 both, huh? 3? 3 also same? 96. 3 also same. 3 also same.
Again.
65. 96 से 65 तक.
in a front page of photo taking video. Front page of photo taking the later reading.
Yes, take to do what? Let's check it up.
Yes, sir.
This is again which police station that's it. 62. This is also Attagoda. Get it to day after tomorrow. Attagoda, both these. This is appeal against acquittal. In the 96, the appellant was about 65 years. Both 2 and 3. Yes.
Item 4.
Yes.
Convicted under section 326/307, IPC sentenced to undergo array for 9 years and under 326
And
5 years, and directed for to run the sentence consecutively. Status report was called for. I'm in custody for 8 years, 5 months. That is the status report for us.
Last time I have already watched.
8 years?
8 years, 5 months I'm in custody.
But out of 14 years.
No, 9 years and 5 years consecutive.
Consecutive.
Nine.
Nine.
That is why
May I read the part of the judgment?
Here let us see.
yes.
Page number 48, my lordship, second paragraph.
Okay. Then 40.
48, page number 48 of the judgment, second paragraph. It starts from second paragraph.
Yes.
Taking rival submission into consideration, I sentence the convicts, namely Bhakti Santosh Kumar Vedanta and Anil Biswajit Singh Rai, to undergo rigorous imprisonment for 9 years and to pay a fine of 10,000. In default, to suffer a rigorous imprisonment for 6 months for the offence punishable 307 and 34 of IPC. The rigorous imprisonment for 5 years and to pay a fine of 5,000. In default, to suffer a rigorous imprisonment for 3 months for the offence punishable under section 326 of IPC. On realizations, the fine will be paid to the victim under section 357 CIPC as a compensation. All the substantive sentences are run consecutively with one after expiration of other. If one is expired, then another.
What is this?
My lord, yes, my lordship. After the expiry of the 9 years,
After then 5 years will start. This is the sentencing.
this is
He has to go, he has to know fundamentals.
but my lordship, the offence they have done is a very.
Whatever 307 you convict, as well as you convict for 326.
So same
9 years and 5 years and say it will go consecutive. Is this?
In the photograph, if you lordship,
Whatever, that is not the issue. Whether this sentencing is correct.
what
For same offense, same
transaction.
transaction, you convict for 326 also, 307 also, and you say that it will go consecutively. Fantastic. Yes, on merit you tell me.
My lord. Merit, my lord.
9 years you have undergone. How much you have undergone?
Yes, 8 months actual sentence.
8 years?
5 months, 17 days actual sentence.
8 years?
That
7 months, huh?
I've
5
handed-
months.
8 years, 5 months, 17 years, 70 days actual sentence.
70 days with 7. 70.
7.
17.
17 days as on 7th of August.
As on
7th August.
26, okay.
Without any remission. The actual sentence here, sir.
With revision it will be about 9 years. Okay. Yes.
Malat, Malat, I will confine my submission to limited in 3 points only.
Yes.
First of all, Malat, this occurrence took
So is the injured. Who is the injured?
is CW3.
CW3.
The basis of the case, Malat, first the occurrence took place in the year 2009.
Hmm.
After investigation, final report was submitted by the police. Thereafter, in 2017,
Hmm.
again on the application of the victim, investigation was reopened by the police and investigation was carried, and thereafter, Malat, then TI parade was conducted. Then trial was commenced and conviction. So after 8 years of Malat, the occurrence, when the final report was submitted, the investigation was reopened.
Yes.
Second, Malat, this if your lordship will see the FIR is well, at this delay in lodging FIR, no the petitioner is appellant is named in the FIR and his victim disclosed the name.
Let us see what are the nature of injury. What the doctor says, let us see first.
First,
Then we'll see.
the FIR warrant allegation. Paid
Come to PW 3.
3.
Your name is
PW3.
Santosh Kumar and Biswajit.
Padmini Baula.
Anil.
Running page 95.
Yes. Occurrence took place on 8th April 2009 at about so. That day I was returning from my aunt's place, sitting in the cycle with the accused persons. Also, acid attack.
My lord. Then stated that he immediately disclosed the name, but my lord, the FIR was lost. FIR was lost, my lord, after occurrence took place on 18/4/2009 alleged, and FIR was lodged on 4/5 about my lord.
First, let us complete one.
My-
I'm reading PW3.
PW3, my lord.
What kind of injuries you have caused? Let us see.
The 16 is a doctor.
The left ear has been totally destroyed. Both eyes damaged. You become completely blind.
No. Thereafter, she recovered, and in the TV program in 2017, she saw the photograph of the petitioner. Thereafter, lodged the FIR. Again, reported the police. Then
When the incident taken place,
2009.
2009.
9. Investigation. When final report was submitted. Then my lord,
Because nobody could be
my lord.
found.
No,
And-
no, no. Could be ascertained the identity
Yes.
of the.
Then she saw that in the TV.
See, in a TV program, my lord, it's victim's evidence, victim statement is that.
Where
Victim's evidence, my lord, in paragraph. Paragraph last 107 page of the paper book.
107. Yes.
Last paragraph of the victim's evidence.
It is not a fact.
It is a fact that I have stated before the police that on 5/9/2017, I had stated about the occurrence in a program, namely Asara Aloka. That program was telecast in TV. It is a fact that in that program, the photograph of the accused Santosh was shown. It is also a fact that I, along with my brother and uncle, went to that program. Then, so this is the thereafter. When at IO's evidence stated that thereafter she made a complaint before the investigating officer, who reopened the investigation and then apprehended the appellant
Yes.
and put to TI period those things.
Doctor?
Doctor is PW.
PW 16.
16.
Yes. Yes.
The nature of injuries was grievous in nature. the
Paragraph 4 and 5.
height unless following injury, chemical burning on the chest, and the nature of burning is of various nature. We burn surface burning.
Head, face, neck, chest, both shoulders, and both
Both
upper limbs. Nature of injury was
Previous in
previous in nature. One
That is at 320.
surface injury. The injuries are fatal to life. When she was taken, she was not in a condition to speak.
So the victims,
Eyewitnesses also there.
the
my lord.
victims, some other informant,
Who is the eyewitness?
PW 7.
7 who accompanied the
Doctor.
victim.
7. Let us see 7. Seven, huh? Eyewitness.
That day we are returning to our house and going. There's one motorcycle.
On that day while we were returning,
The sunlight the accused person came by one motorcycle and just crossed us. And that time the accused Andy was riding the motorcycle, the accused Santos was sitting behind. After crossing us, both the accused turned the motorcycle and came towards us and stopped in front of us. So I got down from my chest. Down to my bicycle. Santos came and I said,
Santos came and asked the victim. Santos came and asked the victim whether she would marry him or not. Stated that Jyoti more woman therefore brought out bottle of from the bag and poured a seat on the head of her victim. And the victim cried loudly. Then Santos has poured.
Yes, Santos. And in his previous statement in earlier first investigation, he stated that I do not remember whether on 4/5/2000 I have stated before the police that later I came to know from the victim the name of the persons who had poured kerosene acid over the sun, and his name is Santosh Vedant. That by that time, that is why due to
Yes.
that is the investigation was closed. All those statements have been recorded after 8 years of that
but
occurrence.
after the victim is recovered, then
Because
she
and
get
same
the
texts were taken by the investigating authority and submitted final report. Again, Malat in 2007, after that program.
Investigation and thereafter.
Madam.
Yes.
One time, Malat, though the and even accepting Malat this statement of the victim stated that immediately she disclosed the name.
I can only convert the sentence to be from consecutive to concurrent. That's all.
One, that,
Beyond that, nothing can be done.
My lordship,
that is
there-
Malat, only my point of submission that 16 days.
Consecutive
delayed the
can be
logical fact.
concurrent. That's all. Beyond that, there is nothing. It's heinous than, in fact, the murder.
One setting, the intention P07 would not be applied. Because that will Malat, the
Three.
intention of that and trial court has also hold in the one paragraph.
307 not attracted in this case. Are you sure?
Because Malat, the intention, Malat doesn't
Oh,
sufficient.
there is no intention.
There
Huh?
is one line.
You ask, you say that will you marry? If you will be mine,
Malat, it is
it's
not-
all right. Otherwise, I'll.
At the outset, Malat, my submission, I am not on that point, Malat.
Better you don't
Yeah.
argue.
See what-
I will issue notice for enhancement. You argue.
The statement that there is
I'll
nothing.
tell you, if you argue the matter, I'll issue notice for enhancement, I tell you. This is the case, it should be
That's-
enhanced. More than 10 years. I'll issue notice for enhancement. Stop here. See the manner in which you have
That's maladies.
very, very heinous. And I'll impose the heavy fine. Even after maintaining consent.
And if your
You leave
lordship
it.
then applied for the bail, my lordship.
Since I'm not, I'm only confining to the sentence part. And sentence is, what is the 5,000 rupees? What 5,000 rupees? You have to pay. Consecutive को concurrent करके fine increase. This is a case where notice should have been issued for enhancement.
None.
So that's the reason the trial court had no option. Oh, he said consecutive because the nature of offense is such.
Fine amount
That
imposed-
part is wrong. That part is wrong.
Fine
They
amount
applied
imposed
for
is
the
5 years.
bail.
Huh?
They applied for the bail and the girl has given the photograph, just had a glance to that.
Very, I can't. These are not part of record. She's completely gone.
Could have been,
Her life is spoiled.
could have been more malad after 326 amendment because it was occurrence of 2009. That is why 326A has not been invoked. It has come into force after in 2013.
That's why my
Judgment.
lordship was consecutively for 4 years after the expiry of the 9 months.
Yes. Yes.
Item 5.
In this case, the officer has been admitted. I condemn the delay that the petitioner is eligible for 3 months. And in the meantime, what happened, mother of the petitioner died on 6/8/2026. I filed an extension of the period. On 6/8/26, mother of the petitioner died.
Interim bail was granted to you.
Yes, on 5/5/26.
5/5.
26 for the period of 3 months. That is going to be extended to late.
Today.
Tomorrow, too late. Because the petitioner released on the bail on the 13/5.
Right. White petitioner ability is convicted for offense and so on. While admitting the appeal, on 5/5/26, while admitting the appeal, petitioner the appellant was granted 3 months interim bail.
On 2 months.
It is going to be expired tomorrow, na?
2 months. 2 months.
On Saturday. Meanwhile, the mother of the petitioner has expired. Therefore, the petitioner is seeking extension of the interim bail. Interim bail. When the matter was taken up, on mentioning, the state council was directed to verify the fact. Verify the contention raised by Mr. So council. The IIC Palangir has placed on record a report dated 10/8/2026 in the stating regarding head to the provincial report, the interim bail period is further extended for 15 days.
Right.
20 days for 20 days. With same conditions. Same conditions. He shall, after reviewing the interim bail period, he shall surrender and file the surrender certificate. Yes.
You also get IAC Sointala.
Bolangir लिखते
District Balangir. IAC Sointala.
Okay. Okay. Yes.
Item 6.
My lord, here, out of 5 years conviction,
Yes, madam.
must
We ready? Tell. You don't argue later. She has to address.
yes.
This is the matter where out of 5 years you have already undergone.
He spent near about 4 years.
No,
There was no allegation of aggravated penetration and also with no medical examination, nothing. Only the allegation made by the victim.
but letter say that.
Ah, yes, yes.
Yes, she should say. Yes.
Effect of more receipt for another day.
ଯାହା ଅଛି ଯେତିକି ଅଛି ସେଥିରୁ କୁହନ୍ତୁ. Have you read it or not?
How did it cost?
No. Bail matter. How can I? I'll pass it over. Read it. Let her read. You may not come. Let her read. Today only, because this matter I have already granted bail since the victim was not appearing despite service. I wanted to give an opportunity, so therefore I have appointed you. Because out of 5 years sentence, he has already undergone more than 3.5 years.
3.5 years.
3.5 years.
3.5.
So therefore, substantive sentence he has already undergone. The appeal is not likely to be taken up. 2025 appeal. It will take some years to be taken up. So therefore, I have decided to grant him bail. But without issuing notice to the victim, I could not have done it. So therefore, I have appointed him. Okay, you read it. Read it and come at 12 o'clock. Let her read it. Let her read the judgment and try to say whatever you want. Okay? Okay. Yes.
2 o'clock.
2 o'clock? Okay, let her read. Yes. Yes.
Item 7.
Yes.
My lord, I am on behalf of Mr. Naik.
Yes.
I am paying for adjournment in this behalf.
Why adjournment?
My lord, Mr. Naik is detailed.
Okay, he's not well. Okay. The counsel-
Someday after 17, because the process has already given the optional task of 17.
Then when do you want you to do it? 21st. Huh? 21st. 21st only? 21st. Okay. 21st.
Item 8.
Should I kindly take up order dated 29/7/2026?
Yes, Lord, that charge sheet has been submitted and that the inception of the proofs. Lordship, I am appearing on behalf of the number. That is the good.
That was not instruction I wanted. I know charge sheet has been filed.
Say that compromise ही है.
Hey, that I wanted.
Petitioner जो informant counsel था. I am appearing on behalf of.
Where have you said that? Settle the matter. Meted a settlement agreement. Copy before I.
Settlement है ये.
Say settlement agreement. Fine. Okay. I'll pass the pick number. Item 8. 8. Pass the. Yes. Yes. I'll pass it.
You said has to be.
Pardon to make a mention, Lord.
Any status report?
Yes.
Status report 1 to
Item 1 to 7.
1 to 7. You got any report? Just
Seven could not establish only
yeah?
Seven could not establish their address not found will Lalbag Thanar भी बुझी थी plus से जो present address देते थे भुवनेश्वर से दीटा जगह बुझी गई.
What about the first 96 matter?
Second, I have received the instruction.
Second you got. What is that? Second item, second. First one
Notice.
not received, huh? Not received. Second one just see. Yes.
And also there was some. Not. But then they're saying that they could not get the whereabouts.
Sorry?
Could not get the whereabouts.
Get it?
The whereabouts of this person.
Then who will get it then?
My lordship, he written a letter to the IAC and he is saying we don't know because after this offense, my lordship, they have left the village. He has written, my lordship, that IAC is.
Councils are appearing, but today you are appearing. What do you say? Yes. Item? We are talking about two now.
2 years.
Two you are appearing?
Yes, your lordship.
What do you say?
Your lordship, we have also tried establishing contact with the person, but.
So they are not able to contact you, are not able to contact you. Let us proceed with the matter.
Next week.
Huh?
Next week.
Let it be there. I will take it up. 96 matter, Thursday. 96 matter. Yes. 3, yes.
Item number 3.
I'll take up the matter on Tuesday, next Thursday. Okay. Yes.
We lost as per order dated 18/7/2002. Sir has been appointed as an investigative assistant. He's on his legs in
I'll pass it over. Huh? Pass.
No,
Yes.
the instruction has not been received. Thursday, my lordship.
Yes, Thursday. Yes. Next. 4.
Item 4. Consent.
4.
Item 4.
Got any information? No. Why you have taken time? Thursday, let it remain. You get Thursday. Okay.
5.
5. Yes, 5. Have you got any instruction? No. 5. Order dated this feature the service has not been complied by the state council. He seeks one more.
Number ही लगून.
Okay. This Tuesday. Next Tuesday. Yes. 6.
Because 6 I could not contact the IAC. Thursday पे ही Thursday भी तो नहीं कर सकता.
Thursday.
I was still
7. You said
Item 7.
7
not traceable. You said.
Yes, your lordship. From Bhubaneswar as well as Cuttack, both.
7 na?
Bhubaneswar, Cuttack, both जगह पे कुछ नहीं था.
A phone call. Pursuant to the order dated so and so. Order 7/7/2022. The report has includes the report from the date on the court. After the report, we are about of the applicant the arrest. None appeared for the applicant. So none appeared for the applicant. You are appearing for this matter?
No, next item.
Okay. None appear for the applicant. Therefore, Mr. I am appointing Abbas. Mr. Abbas Mahanti, who is present in the court, is appointed as a magistrate to assist the court. Assist the court. Lease the matter. Next.
Lordship counsel is there.
Who?
7 items. for the-
7.
Yes.
You are there. You have not appearing since last
No,
2-3 years.
no, Manas, the status report was sought for. That's why the government, my lords, has.
But you last on
was
30th
there.
June you didn't appear. Again 7/7 you didn't
I
appear.
was there, but
Today also you are sitting. And
no, I just.
thereafter 14/7 you didn't appear.
No, Manas,
And thereafter again 21/7 you didn't
I was
appear.
there because my lords has sorted for status report.
That's right, but you have to appear at least.
Manas.
Once I appoint MHQ, then you will come.
No, Manas, sorry, Manas.
I can't wait for these matters. Get ready.
No, the status report actually I thought.
Forget about status report. It is your appeal. If they are not able to ascertain what to do, I can't wait for infinity. Either you tell me or they made an attempt, they are not able to find out.
Then I'll argue, Manas. I'll next week Manas may post it because
Don't to appear,
next post.
submit that argue the appeal on the next day appeal, release the matter on Thursday. Get ready for Thursday.
Minus.
Yes. Yes.
Item 8.
Mr. Sarthak Naik is there. Somebody is appearing for Sarthak. Somebody appeared in the morning.
My part of it I will do. If his junior is there.
Oh, his junior should be there. Otherwise, the hearing will go waste. Somebody was there. For Mr. Naik.
Nobody is coming.
शो करो डिस्प्ले डिस्प्ले शो डिस्प्ले रे शो किस तरह
How good it is. 136.16.
First, another vigilance matter is being scheduled by your lordship.
Yes, that's right.
So it will be better if this matter is taken up today.
I'll just pass over. Let us see if he comes.
This matter, Mr. Sarthak Naik is suffering from fever matters. I've just texted him to join the VC. He said that he's suffering from fever.
Somebody mentioned in the morning. Mr. Sambit Mahanti was also appearing that matter.
I just texted him right now to join the VC. He said that he's suffering from fever.
I was not there. If mention was made, then I have no objection.
No, not in this matter. Some other matter.
My lord, he requests to take it on a Thursday.
Okay.
He has gone to consult the doctor also.
Okay.
Thursday.
It is informed that Mr. Sarthak Naik appearing for the CBI is supposed to release the matter. Let it remain in this court. That particular matter cannot be taken up today. 7 of them.
Mr. Sambit Mahanti.
Yes. Okay. Okay, then
Thursday, my lord?
let it remain.
Yes, let it lie out.
Let it remain.
Grateful.
Yes.
Other matters, I am not ready. There are a number of matters.
Like this 9 is your matter.
9 is my matter. That is also Republic of India.
CBI, okay. And 2000 matter, that is 10, item 10, you are not ready.
Stay these 2 matters, they are already
Next,
there.
what about 10?
We will,
Item 10.
10 we will take up on Tuesday, coming Tuesday.
Because these are the old matters.
Yeah, I will.
No, let us
I will do.
concentrate in old.
I will cope.
Okay. Okay. Revenue report. Okay. 11.
Item 11.
And after you conducted a case,
Next week, my lord.
CBI matter, my lord. Republic of India.
Again, CBI matter.
Recently, I have appeared, my lord, after notice from the Honorable Court.
That's right, but Mr. Naik is not paid.
Neither.
So
Perhaps
let
he is
it
asking-
remain. I will not say anything. Let it remain.
Let it lie all.
Okay. Right. Okay.
12.
12.
Yeah, I have convicted Millers. Only Miller, they demanding 500 rupees. Miller. So this case is in the year 2003, Millers, the case was initiated. The conviction was in the year 2010, Millers.
Vigilance.
Vigilance. Miller.
Yes.
So Millers, I have already submitted the written order submission.
Yeah, no?
Because Miller, it was had by lordship the
That's in fact, a convenience note has also been filed from our side on 6/12/25.
both parties will fight Millers.
It's a raid trap case.
Yes,
Yes,
7.
The 500 demanded was the present appellant was the VLW, village level worker Millers, and
Like
working.
VLW, you think VLW will ask for 5 lakh rupees?
No,
VLW,
500.
Millers.
Obviously,
Yes.
VLW
Yes,
level is same. Na?
That's only he has no nexus because why I'm saying my lord. The
Last
prosecution brief is my lord. The house of the informant was damaged in the year 2001 my lords, due to fraud my lord. And in that respect, my lord, 22,000 was sanctioned by the government my lord, the Indira Awas Yojana. And the video is the sanctioning authority. Because and he had got the amount my lord, the 2 phase. And after the inquiry of the JE, and the money was released by the DDO. So now, my lord, I have no connection with the release money and my lord, whatever my lord, they give the money to the persons, I have no connection. But the allegation here, my lord, I am demanding 500 rupees to the person for my lord, the release of the said money. But it was my lord, my role.
Who is the decoy?
Dr. my lord,
because
PW?
yes, PW
8, my lord.
8, my lord.
Page 61.
PW
Come to,
8.
come to his statement first.
Yes,
61 months.
that's 61.
Come to his evidence. Let's see the sequence here.
So I'm the complainant. I know the accused person. May I permitted it?
VLW, so Panchayat.
Gram Panchayat,
Total.
2020.
400. I was to get a balance of rupees 2,500.
2,500.
Supervising officer.
Yes.
They approved the accused. He demanded 5.
Yes.
So releasing the balance allotment.
Yes. He demanded the rise, made with recent report. Provisions from 5. He gave a report for that.
Then my lords may kindly come to page para 2, my lords.
Yes.
Page 2, para 2.
Yeah.
The date of incidents. Or should we have it?
Yes, yes, I'm there.
Well, just place it, man. After the work
There are
over.
fees and so on. So I had combined so on. So I have brought and handed over the tainted notice. I handed over the.
I and accompany witness proceeded towards Panchayat office. Manoj, this is important. Accused was sitting in his office and seeing me ascertain if I have brought the money. Then I handed over the tainted GC notes to accused and he accepted the same in his own hand and put in his shirt pocket. The
Demand and acceptance is there.
Yes.
Yes.
Lordship, cross-examination part, Lordship, may kindly.
Yes.
Paragraph 3, Lords.
Which para? 3.
Lord, yes, paragraph 3, Lords. Video has sanctioned the Indira Awas house. The money was being given from the video office in shape of check. I had got the money in 2 installments. The block overshare was measuring the construction and only thereafter the money was being released. A sum of rupees 22,000 was sanctioned for construction of the house. I do not remember the amount received by me under first installment and second installment. But so far as I remember, I had received 20,000. Second, third work of the construction was already over, and only 1/3 work was left to be completed. I had not told video about payment of balance amount and had told to VLW. Overseer as office came to for measurement. I had not called the overseer for measurement. I cannot say name of the scribe of the FIR. I am illiterate. I cannot say the contents of the FIR. I personally had present the written report, and the deed writer has not gone with me. On the report of VLW regarding flood damage, I was given ₹400 towards flood relief. I do not remember the date when I had presented the report, but it was during 2003. During evening, I had lost the report, and on the next day morning, I went to vigilance office at 7 a.m. I cannot say name of the persons who were present in vigilance office during my arrival. On my arrival, the vigilance DSP told me to narrate the grievance. I disclosed the story. I cannot say differentially, but my narration might have taken 5 to 10 minutes for the half an hour. Because the DSP, the person has narrated the entire story in front of DSP pillars. And DSP in this case has not been examined pillars. DSP has not been examined. And as for direction of the DSP
you
was
concentrate on demand and acceptance.
Yes, so Lordship mechanically similar. He said, well, the 5 notes of currency, well, the 100 notes of 5 numbers of 100 notes was the seized from the persons. Who was the independent witness? All the prosecution witnesses are the official witnesses. I have also been examined the 2 numbers of witnesses, the defense witnesses. One of the 2 persons are present. Sarpons is given the statement, and the other persons, those who are receiving the rice, paddy rice, because at that type of time, 10 to 15 persons are there for receiving that rice below, but that was a distribution time below. He examined in the case below, and he stated that the person has came to me and they want to change the notes below, the 500 notes. I have given the 20 numbers of the 10 rupees and the rest of the 20 rupees. So therefore, here is say the 105 numbers of 100 rupees have been seized from the persons. And my role, I have not the sanction authority.
PLW is keeping change with him.
Yes, my lord. It was been examined. Lordship may kindly see, my lords. Yes.
What kind of fantastic defense. Yeah.
So now, my lord, my submission.
How will you get over this presumption?
No, Lordship may kindly for a moment, Lord. All the officers are outside of my lords. The only official witnesses, my lord, those who are not, my lord, acquainted with the fact, my lords. Some of the assistant engineers, some of the municipality officers, those who are present in the riding team, my lords. And now, my lord.
Then why should you doubt them?
So, Lordship, my kindly say, my lords, I am not a sanctioning authority.
Maybe
and person says, my lord.
Those are the secondary issue. First of all, there was a demand and you have accepted, you have to discharge that presumption. So, it's a rebuttable presumption. Once you accept the bribe, then unless you give a plausible explanation why you are receiving, so then you are gone. Even if demand is not there, once you accept, that is enough for the purpose of conviction.
So, Lordship, for a moment, my lord, the PW4, my lords.
Come to your
PW4, because the PW4 is the Panchayat, my lord, the working as head clerk. Head clerk also same, my lord, stated, I am not the sanctioning authority, plus cross-examination part. The BDO was the sanctioning authority and also the authorized. Under the above scheme, the beneficiary personally constructed the work and after...
Come to page 105.
Plus the
313. What is your defense? In 313 you have taken?
Yes.
What is the evidence you have?
Question 19, page 13. Page 39.
25, question 25.
PW?
105.
Well, I'm sorry. That's not reaching it over.
Paper book immediately after the judgment, and you get
the statement.
That is actually 40, page 40.
Page 39, Malas. That's what.
39.
13.
Yes. What was your
Inspector of Vigilance? That is. Yes.
Question number 9.
313 statement. That is question number 25. Read it.
Page 40. Yes.
Page 40. Yes, ma'am. Cross-examination part, that was mentioned.
No,
the last question. Question number 25, page 40. Internal page 40. You have heard the evidence of the witness. What else do you want to say?
What was your defense? And what kind of evidence you are leading?
Yes, yes, my lord.
Yes.
Let us make that. It can be. I'm- My lords,
Read it.
the 25. You have
You have not,
you have heard the
you have not
evidence
read,
of-
not read. These are the very
No,
important
no, because
things.
that document page mismatch, my lord. That is.
But have you read it earlier?
Yes, yes, my lord.
Yes.
I've read. That you have heard the evidence of the witnesses. What else do you want to say?
Your defense. This is your defense. This is the rebuttable presumption. This is the stand you have taken.
Yes.
What the stand?
ମୁଁ ସେଦିନ PDS
ଚାଉଳ ବାଣ୍ଟୁଥିଲି ବର୍ଷା ହଉଥିଲା କରୋନା ତା ମଧ୍ୟ ମୋ ଚାଉଳ ନେବାକୁ ଆସିଥିଲା ତାପରେ ସେମାନେ ଟ୍ରାପ୍ କଲେ ହ୍ୱାଟ ଇଜ ୟୁର ଡିଫେନ୍ସ ୟୁ ସେ ଦ୍ୟାଟ୍ ଚେଞ୍ଜ ନେବା ପାଇଁ ଆସିଥିଲା ଇଏ କରିଥିଲା ସିଏ କରିଥିଲା
So that has not been.
why have you not said that
Yes, my lord.
and now you are leading defense evidence in a different direction taking a different stand then you are not
The time of
properly
bringing the
prepared
charge,
the case
no,
for
that is-
conviction they think over
Yes, like at the time framing the charge,
prepare
that
it
is not
properly
even
you are
taken.
not prepared
No, that is my lord. It was.
313 first time you are
Yes.
seeing here don't take that chance read it once again it's a very difficult case for you
Next,
Because
next
it,
Tuesday.
has, it has not been stated anywhere. That is a lot. That is very crucial.
very difficult case therefore
Yes.
you have to prepare rather if it is acquittal case immediately I'll reserve the case if it is
No, my lord,
case I
no.
give an
And
opportunity
in fact,
No,
none of the prosecution witness has been suggested.
very
this
different I've seen it
None of them have been suggested this
So
question.
that
on this,
is my lord. Only my lord that.
and he says that he is not the sanctioning
That
authority.
is not taking the stand.
that is immaterial
Yes.
that is completely immaterial
Yes.
there is demand if I disbelieve demand also
Yes.
okay demand is not believed
Yes.
once you have accepted then the presumption operates against you. You have to discharge that presumption
Section
by way of
20 swings
irrefutable
in.
evidence.
Right.
That evidence flows from 313. What is your stand?
What is the difference?
Thereafter, what evidence you have laid?
That is there.
So then, you could not discharge the burden
Presumption, yes.
of presumption.
Is admitted.
You have accepted it. That has come on record.
That is he himself admitted because at the time of.
So then, it is a case of conviction. What?
I'll get the chance, my lord. Otherwise,
So read,
because the person.
read it, find out some judgment. If you can let him try.
Yes, let's say, apart from everything, if a lordship permit me, I can say 2003 case, my lord.
That is that.
Please,
Those things.
no, it's not. I'm not saying, my lord. 2010, it was done, my lord. The 500 rupees, my lord, the person is now.
See, on those things can be taken into consideration. Had it been in a penal offense, then for the purpose of probation and all, I can give it. Here, I can't give probation also.
Because vigilance, my lord.
Vigilance.
Special act.
So therefore, nothing can be done. That's the difficulty. You find out if anything can be done. You tell, assist me. I'll try to do it.
I don't feel good.
Take this out copy.
Actually, I've received, just now I've received the whereabout, and the whole appellant has been done.
Whole appellant or part of the appellant died?
No, I love only. Sorry. Sorry, my.
I thought part of the appellant died, part of the
I may pardon, my lord.
3 records. So appellant है.
आमने सॉल्व कर
Rafiq Khan. He was 83 in the year 96, obviously he died. Wrongly, report. No. Abated in the absence of application. Yes.
My lord, item number 33.
Sorry. Item 3. Still you want to argue. You didn't understand what happened. It's abated. Yes.
My lord, item 33. I'm told that I have been engaged as an amicus curiae and I have been supplied with the documents. And I am ready with the case to argue, my lord.
33.
Yes.
Who will do it? Yes.
70 also I'm ready. I'm taking 2 p.m.
Before that, if anybody is ready, you, Mr. Vanti, you? No.
29 Pathan.
Yes.
29.
29.
29.
You are appearing in 29?
yeah, first matter. or not a point.
Second matter?
It's the second and first day.
No. But let us read it. The same offense?
Or together,
Ah.
they are connected with each other. Lordship, kindly, Lordship, first day,
What is the offense?
Lordship, 366 year, Lordship.
366.
10 years of conviction.
Okay. You are co-accused. You are the co-accused. Okay. Let it remain, huh? Let it remain. Have you prepared you prepared what? Note. You have prepared note? No.
I have brought it today, which is why I am requesting.
Take her note also, just see. If you want to add anything, you can add. Give her a note. Take the note.
Yes, ma'am.
Get ready according. Yes. Let it remain, huh? Which next? Yes. Thursday. Yes. Yes. Partner. Then we'll start. His matter. Let us start.
33, madam.
34, huh?
33.
33. Okay. Let us start. Yes.
Item 33 kindly pass over.
33.
Yes, ma'am.
Why? What is the offense? What is the offense, by the way?
376 and 3 SCST Act.
I will note it down. Let him start.
Okay. Office, okay.
Who refused? So who recused? Recused from this matter. Recused from this matter. On the previous date of hearings, none appeared for them. Although Mr. Mishra, he refused to appear. Yeah. And hence the matter has gone unrepresented. We have not appealed. Therefore, a point show. What is the difference? Yes. Yes.
Not a recording.
Yes. I have recorded in order. Yes. Yes, Mr. 376.
376 and 3111 of SCST Act, my lord.
Yeah. Yes.
Challenging the judgment dated 2010-97 passed by the Sessions Trial, passed in Sessions Trial number 2 of 97 by the learned Sessions Special Judge Balangir, convicting the appellant under section 376 and 3111, Roman 11 of SCST Act, and sentencing thereunder to undergo RI for 7 years and 3 years, which will run consecutively, my lord, concurrently.
Yes.
First, my lord, I'll address your lordship on SCST Act, my lord. Thereafter, I'll come to 376. Your lordship may kindly see Rule 7 of the SCST Act.
Not followed? Rules
Not
not
followed.
followed. When the offense taken place?
Offense taken place, my lord, 2396.
Okay. Yes.
And
So who is the IO?
I use inspector, my lord.
Show me. Yeah, the rule came into force in 1995. 95. Who is IO? PW?
W11.
11. Let us see what is his position. Yes. 7 is the IO.
Unfortunately, my lord,
Yes.
page 40, my lord.
40, yes. 11. 11 or 12? 11, huh? Must be 11 only. Yes, 11. Yes. IO. What is the present post? Yes. 33. Yes, SI police.
My lord, SI police.
Yes, charge sheet is filed by SI police.
Charge sheet is filed by SI
Gone.
police.
3 SCSC gone. ठीक है? SI police.
The DSP rank.
DSP rank.
See the charge sheet final form.
No, I have gone. DSP rank.
Yes, 3
The
SCSC.
second point was with regard to 3 SST.
The final form also filed by
SI.
SI police.
My lord.
Amarendra Rana. That is PW 11.
The second point with regard to 3 SST was
Final form.
actually there is no point in submitting the second point.
PW 18.
May I show a judgment, my lord, in this regard or not?
Yes. Gone. Yes. Now come 376.
My lord.
Let us see the prosecutrix.
Yes, my lord.
PW?
PW1.
PW1. Let's see that. Yes.
May I read it out, my lord?
Yes.
I know the accused who belongs to village Morundi. My maternal house is situated at Morundi. My marriage with my first husband Jairam Sani, that is PW6, my lord, of my village Morundi was solemnized about 7 years back. My ex-husband Jairam has about 6 acres of cultivable land. He grows vegetable also. His vegetable garden is situated in village Odumundi adjoining Morundi. Occurrence took place on a Saturday at about 9 a.m. at about 1 year back. I had come to vegetable garden at Podmundi. I was alone in the vegetable garden in which we had grown tomatoes. When I was plucking tomato, accused Babulal came there and moved around me. Thereafter, he dragged me to the thatched cottage belonging to us, situated in the vegetable garden. He caught hold of my sari from behind and physically dragged me to that cottage. I raised alarm, upon which the accused threatened that unless I remained silent, he would assault me. In the cottage, he removed my sari and torn my blouse. He laid me on the ground near the tin door. Thereafter, accused Babulal removed the lungi and sunso, which he was wearing. In that process, I sustained injuries on my elbow, back, and chest when accused Babulal forcibly pinned me down on the ground. Accused Babulal, having laid me on the ground.
18, huh? And there is no order.
That's a deportation part.
No, there is no order set. In one of the matter, I passed an order to call for original.
Lordship, but Lordship can enter with lands at the deposition, Lordship. It's not visible, Lordship.
That's right. Whether those depositions are relevant or not, what is the
Most of them are not visible.
That's the whole difficulty. They will send the same copy from where it is scanned.
Second copy, Lordship, at least we can go through it.
Single copy, nothing is visible. Generally, they destroy it. That's the problem. This which year appeal is 98. I don't think it will be there. Just ask her. Madam, there is the trial court record. Most of the prosecution evidence. Scanned copy of prosecution evidence in the LCR is not visible. Therefore, it is directed to ascertain whether the physical copy of the trial court record is available. If it is available, the same should be summoned. Yes. What is the offense?
Lordship, 302, initiative 302 was there. Subsequently turned to 304. Lordship, that is the main reason. Lordship.
Then that needs to be heard. Yes. 7 years sentence.
Apparent one died only for 53 years.
Okay. Whatever other matters are there. Let us see.
ସବୁଗୁଡା ଜଜମେଣ୍ଟ ଦେଇଛି ମୁଁ।
Let us see the judgment. Which judgment? Yes.
ସବୁଗୁଡା ସୁପ୍ରିମ କୋର୍ଟ ଜଜମେଣ୍ଟ
Ah.
and relating to 376.
No, that is the problem. See, in Supreme Court, they exercise 142. Whether in appeal I can do or not, that's the question.
ନାଇଁ ନାଇଁ ସେଇଟା ଗୋଟେ 2011 ଜଷ୍ଟିସ ଜ୍ଞାନସୁଧା ମିଶ୍ର and ଡକ୍ଟର
Cardio, Marchik.
ହଁ ସେଇଟାରେ ସେ
In that bench, this use happen.
142 ଟା ୟୁଜ କରୁନା।
But the Supreme Court has a power.
There are decisions I have given.
Let me read it. Let me read it.
ଟିକେ ଦେଖି ଦିଅନ୍ତୁ।
If any problem is, then I may list it once again for your assistance. Otherwise, we'll.
କିଛି
Because
ମତେ ଟିକେ ଦେଖେଇ ମୁଁ ଟିକେ ଆଉ ଦେଖିଛୁ।
see, that's the whole difficulty.
ହଁ ହଁ
142
ଆଜ୍ଞା।
and an appeal.
Personal matters. In appeal, personal matters.
No, here it is 307.
ନା
No.
ନା ନା ଗୋଟେ ଦିଟା ହେଇଗଲେ ବି that is sufficient। ଗୋଟେ ଦିଟା ଡିସିସନ ବି ହେଇଗଲେ
ଗୋଟେ decision is sufficient. Dita khan. ଗୋଟେ ହେଲେ ତାକୁ we will enhance it so that it will be used. Have you got hold of any judgment of any High Court?
Relying this, relying this judgment,
You have that High Court judgment.
Delhi High Court judgment ଅଛି।
Give that judgment.
ତ ସବୁଗୁଡା କାଇଁ ସୁପ୍ରିମ କୋର୍ଟ ନେଇଯାଇଛି।
No. Give that. If they rely upon it, then use it. Then that is a High Court judgment.
ଦିଲ୍ଲୀ ହାଇକୋର୍ଟ ର ଅଛି, ଗୁଜରାଟ ହାଇକୋର୍ଟ ର ଅଛି।
Give those judgment. That is very important because those are appeal. They utilize this judgment and reduce the sentence. That's enough.
ଆଜ୍ଞା
That's enough.
ଏଇଆକୁ ରିଲାଇ କରି ଦେଇ ଦେଇଛି।
No problem. Give that judgment.
ଏଇଟା ରଖିଥାନ୍ତୁ ମୁଁ ଆଉ ସେ ହାଇକୋର୍ଟ ର ଜଜମେଣ୍ଟ ମୁଁ ହାଇକୋର୍ଟ ର ଜଜମେଣ୍ଟ ଅଛି ଗୁଜରାଟ ହାଇକୋର୍ଟ ଅଛି, ପଞ୍ଜାବ ହରିୟାଣା ର ଅଛି।
That's good enough.
ଦିଲ୍ଲୀ ହାଇକୋର୍ଟ ର ଅଛି ଆଣିନି।
No, that's good enough because see, these are 142.
ଏଇଟା 142 ନୁହେଁ।
They might not have written, but they exercise that power. They can do anything.
ସେଇଟା ବି ଲେଖିନାହାନ୍ତି, ଲେଖିଛନ୍ତି ଯେ ସ୍ପେଶାଲ ରିଜନ ହଉଛି because of the fact that the incident took place before the criminal Major Act was amended. The special reason ଦେଇକିରି you can reduce the sentence. After amendment, that provision is not there.
That is taken away, that provision.
Again?
That provision is taken away.
Taken away. But I will cover by the old act because the incident took place in 2000.
That is one circumstances where we can use that. So give the High Court judgment.
Okay.
ରଖିଦିଅ ସାଥିରେ ଲଗେଇକି ରଖିଦେବ ଠିକ
শুক্রবার দিন ওটা বেলটা করতেলি
Today it will be uploaded.
আর ମୁଁ ବି ରାଜି ଅଛି 96 ଟା ସାରିଦବ
Aji,
ଆଜ୍ଞା
कर दो
3 ବର୍ଷ ଜେଲ ଏଡିପିଏସ୍ ଆକ୍ଟ
let it be a Tuesday, next Tuesday.
ଆଜ୍ଞା
Okay.
ତାହେଲେ ମୁଁ ଫ୍ରି ହେଇଗଲି
Because the other matters are.
CRLS 679 of 26 was on board on 7th August. Not only that has been kept to 28 to 26. My humble submission is before this honorable court. Since in the meantime the warrant has been issued, I have filed an IA. Let me.
That I want to get it listed.
Report the matter may be fulfilled.
No, insofar as the warrant is concerned, you move an application for cancellation of that warranty in that year.
Next day, along with the IA, so far the order is concerned, I have.
What are you seeking? Quashing? What are you seeking in the main petition?
No, that's a criminal appeal, Your Lordship.
Criminal appeal has been listed on 27th. That has been kept to 20th. In the meantime, the trial court has issued the warrant. Therefore, my bail application may be because 389, 3 power has been exercised by the time.
389.
Okay, yes, that has been exercised.
Please, I understand.
I number 2063.
Offense?
Offense section 4, only for the negligence of duty. He is a police officer. Because of the fact that he has not registered the case, that's why the.
Okay, list for it.
There's the SC/ST only 6 months of conviction.
Only 6 months conviction.
It has to be suspended.
Yes.
Yes. 20. Then it will be tomorrow, huh?
Yes.
I'll suspend it. Okay. Give the IA number also.
Yes.
Yes.
Sir, I got item number 6 weekly list. I already submitted the whereabouts, Your Lordship. He is alive.
Alive.
Yes, sir. Item 6.
6 running. Yes.
Item 6. So, जोड़ा दिल्ली.
Yes, she will argue. Madam.
Item 6.
Supplemented.
My lord, it is a conviction matter. The appellant convicted 5 years arrest and 1 lakh and fine 1 lakh rupees under section 8 Fox Act.
Yes.
My lord, kindly see para 11. Who is victim and as discussed above, as a child under 6 years of age has in her evidence disposed as stated above that on the date of occurrence, while she had gone to urinate the latrine, the accused claim inside her latrine touched both her breast
Hearing item 28.
Right. Okay. Listeners. Yes, the appellant has been convicted under section 354 IPC to sentence him to undergo RI for 2 years.
354 or 2 years.
2 years.
Yes.
Yes, the occurrence have been
With the victim.
Section PW5.
PW5.
See. How much you have undergone?
That should be more than 4 months.
4 months. Yes. About 2 years back, I will see.
Weekly the total search. आज का weekly.
Eta 20, 20, 58, এটা not there. I have a list. It.
Yes, PW.
PW3 is also important.
PW3, you'll also the restricted let's say cross examination para 6. Here, PW6, PW3 let's say.
First para 2 malad.
I heard crying of Sujata and I rushed.
Para 2,
and
I was at a distance of about
accused sitting and Sujata on facing their waist, and I found the accused having sexual intercourse with Sujata, and she was lying in the face of words, and the time yes. 6.
Para 6 let's say stated. We used to pass through the house of Sujata while going to cut grass. I did not see the neighbor of the house of Sujata to have been present on the date of occurrence. I did not have conversation with the family members of the Sujata on the date of occurrence. Then the para 8, one Akhila Naik was the Akhila Naik and the Sarat Naik was the both are the accused. Para 8, one Akhila Naik was also present along with the accused, and he left the spot ahead of the accused. The accused and the Akhila Naik asked me as to why I was cutting grass on the Thursday and crossed me ahead. I was not afraid seeing them as they were my villagers. I was busy in cutting grass by the time they left. Hence, I did not mark them at that time as to where they went. And para 10, I detected nail marks on the breast of the Sujata. When I put on sari on her, I called Sujata.
This task corroborated with the evidence of the victim, PW5.
Yes, PW5.
She saw the act, and she was completely nude, and when this witness came and gave the sari and covered her.
Let's see, she stated that Sujata as Mamina. The headmaster of the school, he has stated PW8, Lordship. Para 3, after I took over charge as a headmaster, the father of Mamina told me that the real name of the student was Sujata, and accordingly he requested to correct her name in the school register as Sujata.
To what are you going to tell?
Difference, let's see, the informed victim and victim name and the
She is Sujata alias Mamta.
Mamina.
PW3 says, PW8 also says Mamina.
There's a different doubt.
What doubt? Rather reconfirms. PW8 reconfirms. Mamina. Para 3. After he took over the charges, the father of Mamina told me that the real name of the student is Sujata.
Lordship, DW1 also said that Sujata is not called as Mamina.
Oh, this is neither here nor there. Who is the doctor?
Doctor is PW6, Lordship. He stated that her age is in between 15 to 16. There was no mark of injury over any part of her body. The hymen is concentric
That is,
that
that is the reason 354, otherwise 376.
then,
Otherwise, it is clear evident from
376.
PWP. Nail mark is there.
there is no injury, Lordship. The para,
That is the reason.
para,
Partly you have been convicted for
354.
354. What is the period undergone, you say?
for
I can give PO. Don't be very
4 months.
4 months.
4 months.
Now his age would be
56, Lordship.
56 years.
PO plus little fine up, yeah. PO I will give. PO plus
1 month for this FIR laws for children.
There was discussion in the village regarding settlement of that.
That is the reason.
That is the reason why they have lost after some case.
Yes.
72. Problem.
The plaintiff is convicted for complaint of NDPS Act Math for 6 years.
Yes.
Allegedly getting 200 grams of brown sugar. PW 1 and 5 are the independent witness turned hostile. The case rests upon 2, 4, and 7. 2 is the DSP manner who came to the spot for the as an authorized gazette officer. 4 is the informant, 7 is the identifier. 42 not complied, neither 50, neither 52, nor 55. 42 is saying, I immediately send the information to SP through one, but he has not been examined. Though other official witnesses are there, they have been examined only 2, 4, 7.
Who is IO?
IO is 7. Who came after everything was done?
IO 7.
Yes. इनके दत्तांतर
Who is IIC? IIC. Who received? Who received the information first?
John PW4.
PW4. Let's see PW4. For the purpose of 42, huh?
Yes, ma'am.
On receipt of the information from reliable source that on Duswant Rao yes, Tangi was usually frequently body to the area of transacting wrong to them also got down at body to the from. I enter the facts in the station diary by the entry number 424. Then my staff about the information. Then I pass the information on the facts of Sub-Inspector.
I also submitted a report to SP.
I also submitted a SP so-and-so.
Constable SP Das. That SP Das has not been examined. Then I left the place at around 10:05 a.m.
That the station diary entry is there on record?
Yes, sir.
Then it's complied. 42 complied.
But across the matter, the gazette officer came to the spot before lodging the FIR. PW2 matter.
When the incident happened?
He received the information at 9:30 p.m. 9:30 a.m. The PW4
Around 10 a.m.
Yes.
10:05 a.m.
May I repeat PW2?
The gazetted officer.
The option was given, my lord, whether you want to be searched before gazetted police officer or magistrate.
Directed over phone. Earlier I was working as the present capacity. He was working as.
And 4 is saying I received even 9:30.
Let us go systematically.
175.
You might have read, I have not read it. Go systematically. You are talking about now 42 compliance.
Yes.
Insofar as 42 compliance is concerned, the IO very categorically says that I have entered in the diary, and that is the entry number 424. And that part is believed, and the entry is also there on record. So 42 is compliant.
Only my submission that information which is given to SP through one entry that she has not been.
No, that might be, but the entry is there. Entry is there. Yes, that is there, part of the record. And next, what is your
50
one? 50, yes. Tell me the 50 now.
That option was given, my lord, whether you want to be searched for a gazetted police officer or magistrate. In the act itself, there is no such option.
Gazetted officer.
Gazetted officer. And
gazetted officer can also be a police officer.
Yes, but the language is gazetted officer, and no option is given as police officer. Because search before police is barred by 25. And process matter that PW2, who is a gazetted police officer, he is saying, getting information from SP, I came to spot at 9:30. But 9:30 he received the PW4 received preliminary information 9:30 and reached the spot at 10.
See, SP might have told both of them, you gazetted officer, you go.
But
that might be the.
But before the PW4 came to the spot, PW2 was already there. Because search and seizure with the doubt.
Where is one of my judgment where I have said that it goes with the raiding party?
Yes,
the gazetted officer goes with the raiding party.
Yes,
that is not the true compliance of 50.
Yes,
Where is that?
On requisition. On requisition. On requisition, then gazetted officer. The raiding party, it cannot be on requisition.
Yes, my lord. Arun Kumar Das.
What have you seen?
Class I am reading, my lord. Legality and sustainability held. Admittedly, the gazetted officer accompanying the raiding party and remained an integral part of the search operation. Such participation clearly destroys the element of independence required under Section 50 of the NDPS Act. The so-called compliance of Section 50 remain illusory and contrary to the settled position as exposited by Apex Court as well as this court. Since the mandatory procedure safeguard under Section 50 has not been adhered to in its true spirit, the entire search and seizure stands vitiated, rendering the conviction and sentence of appellant unsustainable in the IO law.
If the gazetted officer goes with the raiding party,
yes,
and the option is given, then in that case, the Section 50 is not compliant.
Yes, madam. In this case,
in true spirit. That's my judgment.
Yes.
Yes, substantiate that from here. This officer has gone with the party. Yes.
Even before
on requisition.
You were there.
I was also working as a present capacity on that day at about 9:30 AM. SP Kotak directed me to over phone to proceed to so where the police staff.
Yes, detained a person and how, my lord? If that is at 9:30, they got information and went to the spot at 10:05. How that person can got on, my lord, before 9:30?
No, but 11:28.
Yes.
11.
He reached there, but 11:20.
But the information, what is the information directed me over phone to proceed to Balikuta side, where the police staff Sadarpas, PS, detained a person. That means the information was earlier, ma'am, before 9:30. The police staff was earlier there, ma'am. Before 9:30, they were there.
That further creates problem for you in the sense 42 is really complied. Because the IO says that I have informed the SP over phone.
He is not that matter. The informant informed the IO. IO came later, matter. After everything was done, search, seizure was done.
Let us see the first IO.
Yes, 7, man.
7, let us see once again. Then we'll go to
He
PW4
was
again.
called to the spot later.
Being OIC of Jayanta Mahapatra, the
The
OIC
then OIC Sadar Patak on VHF,
to
I
spot.
proceeded to the spot near Balikuda Hanuman Temple. After arrival, I found
Where are you reading? After arrival, I found
and DSP Chakradhara Mahapatra already there, madam. SI G. Vera and other police staff, including Anil Kumar Beuria, Brajakishore Manti, and other accused there.
No, the other witness I have read.
And these persons are not examined, madam.
No, come to 6.
6 is
On the day about 4:30 am, the OIC so Mahapatra called me.
Yes.
That is 9:40.
Yes. So OIC Jayant Mahapatra called me, AIC PK Patnaik, Constable NC Patnaik, and Constable SK Bala, who is official, and inform us that he received 9:40. Fortunately, Mate Dakile, I am Hanare Kohil.
10 minutes here and then how does
Yes,
it?
yes. I am contradicting to that PW2 and with the PW7 because of all the information received to police station at 9:30.
And all these things happen between 9:30 to 11.
And the informant was
5 minutes here, there, 10 minutes here, there makes no difference.
But my submission matter, so how could that DSP get the information from SP that one person has been detained by police before 9:30? Because everything was information received 9:30. And PW2 is saying SP informed me one person has been detained at 9:30.
Let us see once again.
Yes. PW2 minor.
What timing is the problem?
Yes, ma'am. And I stood there from 9:30 to 10 waiting for the police officer to come and search me. To one second, madam. I was also working in the present capacity. On that day, at about 9:30 am, SP Kotak directed me over phone, madam.
Read it full.
Yes, ma'am. On 17/3/2005, I was also working in the present capacity. On that day, at about 9:30 am, SP Kotak directed me over phone to proceed to Balikuda side, where the police staff of Sadar PS detained a person suspecting him carrying contraband articles. I arrived at the spot, that is Balikuda Road, running in front of Hanuman Temple, Balikuda at 11:20 am, and found the accused Dushasana Rao being detained in circled by OIC Sadar PS Jayanta Mahapatra and other police personnel, and also found two outsiders, namely Anil Kumar Behar and Brajaman Mahanti, present under the police personnel. I inquired Sushasana Rao if he was willing to be searched in presence of incapacity of gazetted officer after disclosing my identity. Prior to that, OIC Sri Mahapatra offered option to the accused in writing that the party is not their matter. Then
Mahapatra and I gave.
Then
Our personal search.
I gave our personal search to the accused, so also other staff and with witnesses. The accused searched and he was holding a plastic blue stick bag. On searching the bag, a polythene packet containing suspected brown sugar was found. On moment, the brown sugar came to 200 grams. Two samples weighing 5 grams were collected, packed separately, and sealed with the personal brass seal of Sri Mahapatra. The rest brown sugar was also packed and sealed. The bag was separately at the exhibit A.
Marked exhibit A.
Exhibit. The bulk powder one was exhibit A by 1 and sample packet were marked as A by 2 and A by 3. Then schedule list was prepared. It was signed by me, witnesses, and the accused. and copy of the same was supplied to the accused, scheduled 2 by 3 is
Then 42.
on arrival of SI Encados. Thereafter the IDC convener. On arrival of SI Encados, he was handed over the charge of investigation and other connected papers of the search and seizures, including the FIR tried by Sri Mahapatra. A sealed packet brought from market, brought from and marked as was produced and opened for identification of the witnesses. MO1 is a plastic bag being wrapped with the paper. MO2 is the sealed polythene packet marked as A containing bulk iron brown sugar powder, and MO3 is the small polythene packet containing the sample color in the spot. All the packets were being my signature. This packet are found sealed. It is not a fact that I didn't disclose in my on one statement that SP informed me about the portfolio my deposition to the spot. I suspected powder was made at the spot, that no sample were collected and the sockets were sealed at the spot. That seal was not left in the tune of lubricant that I am depositing for change. Number is in the no written declaration except oral direction was issued to me to proceed to the spot.
If you see the notice, he has written in his own hand.
But no signature is there.
No, his signature is there. Prasad Raut is written.
75.
It's there. Property is at the, if you see,
75.
that notice is there.
Yes.
Notice is perfectly given. Except you say that 9:30 time.
Yes, ma'am.
9:30 or 11 o'clock, how does it make difference? How do we know?
9:30.
See, everything happened at 11 o'clock.
Before 9:30, ma'am. I am talking before 9:30. Because
They got information before 9:30.
got information in the police station, ma'am. That
Everything happened within 9:30 to 11 o'clock.
11.
Timing here 10 minutes, 50, half an hour here and there.
and
That is not substantial.
52 also not compliant. It was to be seized before a magistrate.
See, 50 is complied. 42 is complied. 50 is complied.
50 meant that option that to be searched before gazetted police officer. That option.
Where? See, the notice, handwritten notice, just see.
Yes, yes, sir.
What is written there? Handwritten notice, just see the handwritten notice.
Yes, ma'am, sir.
List of exhibit 1 ପରେ property seize memo ତାପରେ ଦେଖ notice ଏତ ଦ୍ୱାରା ଆପଣଙ୍କୁ ଦୁଶାସନ
ବିଶ୍ୱାସ ମିଳିଛି ତେଣୁ ଆପଣଙ୍କ ବ୍ୟକ୍ତିଗତ କଲେଜ ଦରକାର ଅଛି ଆପଣ ମାଜିଷ୍ଟ୍ରେଟ କିମ୍ବା ଉଚ୍ଚପଦସ୍ଥ ପୋଲିସ ଅଧିକାରୀ
ହଁ magistrate police officer.
but that act says married it used to be gazetted officer or magistrate, not includes police officers
Magistrate
or gazetted officer, but he is saying उच्चपदस्थ police अधिकारी.
Magistrate, X is magistrate or a gazetted officer.
That
Do you have any judgment? Do you have any judgment?
regarding the third option. His third option, only two options is to be either gazetted officer or magistrate. There should be no other option, man.
It says magistrate or police
gazetted
officer.
officer, but he is a police officer, police अधिकारी. That is doubt, man.
Police adhikari, that suppose DSP is there.
No. If this it says something, you have to do the same manner.
Because it was also
Police ଆସିଗଲା ମାନେ as well as 25 contradiction.
Do you have any judgment to that effect?
The regarding third option, I have the judgments. Only two options is to be given, either gazetted officer or magistrate. No other option before me or anything else that should not be given. Yes.
Give me something.
Prepared a note now.
Short. The judgment you give me, and yes, I am giving judgment, my lord.
The state of Himachal versus my lord, state of Himachal versus Surat Singh. Whether such
Give me the judgment. How will I read? Sir. You should have a copy. Give it to him also.
Last day I have given the list, my lord.
He should have the copy. Which para? Para 18.
Yes.
If you para 18, if you see exactly the same situation. Their lordship in the Supreme Court in the case of Suresh and others so and so have held that in a case where the accused were merely asked whether they would offer their personal search to the police officer concerned or the gazetted officer, and the appellant gave their consent for their personal search by a police officer concerned, it will amount to non-compliance of 51 of NDPSA. If the option is given gazetted officer or police officer, and the accused chooses police officer, then 50 is not complied. So the option has to be given gazetted officer or magistrate. If you remove one of them and substitute by an police officer, then 51 is not complied.
Statutory bar is.
Then that itself is a ground for the for 18.
The police officer would have been designated as gazetted officer, not something other.
Maybe, but that is the judgment what to do. Suresh, do you have that judgment? 2013 1 ACC. 2013 1 ACC.
Himachal Pradesh, Surat Singh. I'm having that.
No. This is Madhya Pradesh. Suresh versus Madhya Pradesh. Supreme Court judgment.
Page man.
550. 2013 1 ACC 550. That's the basic judgment.
I have downloaded it from net. This is the
Surat Singh. Himachal.
Himachal.
That is Himachal. Get those judgment.
Yes.
There is only one point. Get the copies of the judgment, give it, and day after.
Yes.
Get the judgment, Suresh.
Yes.
There it says that the only two options, magistrate and gazetted officer. If out of these two, if police officer is substituted, then 50 subclause 1 is not.
Police officer option police officer
There should be no option as police officer.
Suppose
When you are prompting that police is there, then he obviously opt for police. The same thing happened here.
suppose I can notice magistrate or gazetted officer, but CS like police officer.
Then there is compliance.
Some point.
Then it is compliance. But you can't give an option of police.
Police, like.
The moment you give option of police, then you have option has to be these two. He can say that personal search no problem.
Right.
Generally, notice the personal search generally. But you committed by writing it.
Right.
You have written ବ୍ୟକ୍ତିଗତ ତଲାସି କରିବା ଦରକାର ପଡୁଛି ଆପଣ ମାଜିଷ୍ଟ୍ରେଟ କିମ୍ବା ଉଚ୍ଚ ପଦସ୍ଥ ପୋଲିସ ଅଧିକାରୀ।
And witness signature is required in that on that.
No, witness signature is not there, that's another point. Witness signature is also not there, but
accused signature.
accused signature and witness signatures are not there. Two independent witness.
I have book my there contains a mandatory requirements of search and seizure. 20 to 25 points are there. 20 to 25 points are there, which are required for the mandatory requirements of search matter. One point is that it is to be signed by the witnesses matter.
Yeah, that is there. That witnesses have not signed.
And 1 day delay in sending the seizures to the magistrate.
But you concentrate this point, you succeed in this point, then why unnecessary going into?
Lots of judgments are there.
Get the judgments. Yes.
Item 58, my lord. Your lordship already had this matter, my lord. On last occasion, directed a silly point, my lord. Whether the RFSL report is there or not, my lord.
58.
That has to be, yes.
Who had argued?
That,
No.
Yeah, my senior. My senior.
58.
Mr. Mohanty, my senior. Only one point I have raised that.
Okay,
yes, ma'am.
50.
Thursday, my lord.
50 again.
Thursday 58 also just see. You get those judgments.
My item is also same, my lord. The item 58 also identical to my.
Those judgments.
Yes, my lord.
Comparison.
There is a judgment. There is no third option, my lord. There is no third option. Only two options.
There is no third option. But here what happened is, out of two options, one option is the police officer.
Yes, my lord. And
that's the third option, so you can't give it all.
Yes, my lord. And
but once the moment you give the option of police, then you are out.
And and there is another judgment, my lord, of this Honorable Apex Court. The benefit of doubt should be given to the accused when the independent witness have been hostile. In that case, my lord, the procedure has to be complied fully, my lord.
When independent witnesses are
yes, my lord. Yes, my lord.
And
the story in all the cases are saying.
Yes, my lord.
Independent witness never supposed.
Then in this case, when official witness has not been examined, those who associate with that reading party, they have also not been examined.
In Sanjit Kumar, my lord, the Honorable Apex Court given the benefit of doubt to the accused, my lord. सेवा अपेक्स कोर्ट କରୁଛନ୍ତି ସେ କଣ କରିବେ ମାନେ ଯଦି ये witness ଯଦି hostile ହେଇଛନ୍ତି then there should be must be complied the mandatory provision or other should କୋଉଠି ବି କିଛି ରହିବାକୁ ହବନି ଟିକେ ବି ଯଦି ରହିଲା then benefit of doubt goes to accused.
No, see, the problem is if the independent witnesses don't support, it's all right. But they put forth a different story, then in that case,
yes,
says that you have to.
There should not be any lacuna.
That's an I view. That's what the court says.
There should not be any lacuna or laches, madam.
When generally the witnesses say that I don't know anything about it.
Yes, madam.
That is a different story.
Different story.
But instead of saying that they narrate different story.
Different story.
Then in that case, you have.
Yes, madam.
Disputed.
Exactly what happened in my case, my lord.
Disputed.
The same thing has been happened in my case, my lord. Item number 58.
It says once a prosecution comes up with a story that the search and seizure was conducted in presence of the independent witnesses, they also choose to examine them before the court. So then the court, then in that case, the independent witnesses portrays a different story. In that case,
yes, different story.
Generally, they say that I don't know.
Yes, madam.
Nothing happened in my presence.
Police
100% cases are like that.
Signature.
It's just identical to.
In the cross examination, they will say that blank paper signature was obtained. But this is a story in all the. But only we have to see whether two independent witnesses are there or not. Because 50 clause 5 or clause 4 requires at least two independent witnesses. If that compliance is there, then the other witnesses can be relied upon. But here is a different story altogether. In his case,
they created a problem for themselves.
Third option, nahi. Second option is a police option. That's it.
No.
Third option to rakhi paru.
There is no option.
Jadi after the gazetted officer or other things, accuse himself and I want to be sorry before the police or something otherwise.
That is permissible. But if you give these two options as well as say that police option, then third option gone. Here two options are given. Out of two, one is police officer. That is the
In
problem.
my last case,
And Suresh, judgment Suresh 2013, Supreme Court says the same thing. If one option is a police officer, the the accused chooses the police officer for search, then it is completely vitiated and entitled for it.
Option given.
We'll see that.